So I would like to briefly introduce and then allow them to introduce themselves. Jim Shasma is the housing attorney for the Michigan Poverty Law Program, and Jennifer Gray, who is a staff attorney for Northern Michigan Legal Services, who'll be providing us with some information about our legal rights as manufactured housing community residents in Michigan. Thank you. I'll turn it over to you.
Jim, you want to go first, and then I have a little sheet to kind of fill in the blanks.
Yeah, I'll be glad to. Do you want to introduce yourself first, Jen?
Sure. I'm Jennifer Gray with Legal Services of Northern Michigan, and we are basically the legal aid agency for Grand Traverse, Wexford, Manistee, Benzie counties up here, Antrim and Leelanau as well. But we have been dealing with a lot of manufactured housing community issues lately, and I am boots on the ground for evictions, have been doing them for about 10, 11 years now at Legal Services. And so we've dealt with an array of issues, some of which I heard tonight. So we'll be addressing a lot of those.
And as you've heard, I'm Jim Shaftsman. I'm the housing attorney at the Michigan Poverty Law Program, which is based in Ypsilanti, but we do work statewide, and we do direct advocacy, which consists of a lot of different work, some of it with the legislature, some with administrative agencies like MISHDA or LARA, which under whose control is the Mobile Home Commission. And we do some training work, publication work. And then a lot of what we do is also support the work of advocates and organizations who are working on behalf of Michigan's low-income residents. So in that connection, I've had some occasion to work on mobile home manufactured housing community issues. And yeah, there are more people who know more about this area than I do. And perhaps that includes some of you. So hoping that I can maybe learn some things from you, and that there can be some dialogue around some of these issues, because there's certainly a lot of gaps in my knowledge and in the work I do. You know, I discover that it's the people who are being even more directly affected by situations who can add a lot to the work I do. So looking forward to our time together. And what I think we are going to do is, if this is the plan, Jen, I don't know if you want to do your piece first, or I'll do mine and you follow.
Yeah, go ahead and do yours. And I can actually share the screen with your PowerPoint if you want.
Yeah, sure. If you're willing to advance the slides, that'd be great.
All right.
So what I did was put together a short document. It's in PowerPoint form, and it just points to some common issues that I see in the work that I do. So, you know, I don't pretend that this is a complete coverage of issues. There's a lot of gaps, so it's not comprehensive. It's not, you know, exhaustive. That there's a lot more issues out there, but these are what, you know, I'll call common issues. And I know that you're all residents now, and again, you know, if this stuff is too elementary for you, maybe we can focus in on some specific topics. But, you know, the primary issues are related to occupancy issues, so issues that park residents are likely to encounter while they're living in the park. But there's just then a little coverage as well about some issues before and after a rental. So yeah, if you could advance.
Oops, page down. There we go.
Yeah. So, and just a couple of points, and I won't, you know, dwell on this, and I think this pertains to really housing of any sort, some considerations. And I hope that none of you have encountered title issues related to mobile homes, but there are tremendous issues around them. And, you know, oftentimes people who think that they're purchasing a home discover that the seller doesn't have title, and sometimes that can even include situations where it is the park itself that is making the sale. So, you know, want to be sure that the person who, or entity who you're buying a home from has title, whether there's a security interest, so whether there's a lender, you know, who is listed on the title as a secured party, and things like this, the serial number of the home matching the title, because These are all issues that sadly arise in connection with sales, inspecting the home, that there are oftentimes issues that were unknown to a buyer and sometimes concealed defects in a home. And if you're buying on credit, as with anything, any purchase on credit, to be sure you understand the terms of the credit, what you're getting yourself into, and not signing anything that you are not knowledgeable about the contents of, and not to be pressured into this. So again, I know probably for you all, this might be pretty basic elementary stuff, but still, I think points worth remembering. So another common issue that we see is where there is someone's moving into the park and buying from, or wanting to move into the park and buying from an existing residence, is the need for approval from the park. That's best. It may not be essential, but it can avoid some problems down the line. And Paul has already pointed out, and you have spoken to, issues related to the lease and community rules, and we'll delve into rule issues a bit more. And another issue is whether the park has a current license, and whether it is in fact licensed to operate that property as a manufactured housing community. And not all do, and there are ramifications, or should be, and this is kind of in this sphere that Paul was talking about, of situations where tenants may have a right, but it's often the case that no one other than tenants is enforcing those rights on their behalf. And see, as in many other areas of the law, that a lot of entities that have power, like manufactured housing community owners, are often not held accountable to their legal obligations. Licensor is just one of them, and we'll touch on some other areas. And if no one's calling them on these issues, they're going to keep doing business as they've done, which may be illegally, but they get away with it. And I know that several of you and Paul have commented about rent issues. As you probably know, Michigan doesn't have rent control either at the state level, and even beyond that, Michigan law prohibits local governments from adopting any kind of rent control. So, there is not that protection. Yes, that I think, especially with rents as they are going, rent increases as we're seeing them, that there is some need for rent control. Rent caps, I think, was the phrase used. And so either on the initial rent that someone pays, or on increases over time. But there are some limited protections. So there are provisions in the law say that if a tenant, so a park resident, for example, is asserting some legal right, that a rent increase following that activity could be retaliatory and be prohibited. So there are some mild protections under the law. Michigan also has, as you may know, and it has some value in other settings, a Consumer Protection Act. And there's a provision in that act that says that prices, or in this case, rent, can't be grossly in excess of what is charged in similar areas or for similar services. So if the rents are really out of whack with what they are at comparable parks, that could be an issue as well. So, but legally, that's a bit challenging to establish grossly excessive, but it's one of the, again, unfortunately, one of the few checks that Michigan law has on rents, as well as with other charges. But those charges must be in writing. So if a park increases a garbage fee, for example, it's not enough for it to tell residents verbally, orally, that this is going to happen. It has to happen by way of a an amendment or revision of the lease or of the rules that tenants are entitled to notice of. And there's also a law that provides some good protection for tenants, including manufactured housing residents in parks, is the Truth in Renting Act. And among other things, it restricts changes that can happen during a lease term, including rent increases, and I would contend fee increases as well. So if a tenant is living under a lease for a lease term, that there are limits on what increases a landlord, including a park, can make. And there are some exceptions that allow them, for example, if they can show that their property taxes have increased, insurance charges, so some certain costs, that there can be a increase in a rent charge or a fee charge. But the Truth in Renting Act covers other things, and I think landlords routinely ignore some of these limitations, like any charging of attorney fees in connection with a tenancy. And we see that a lot, both within the manufactured housing space and beyond it. And another issue, and this one is a bit legally challenging as well, but it's the law. And so if there's a charge assessed because a tenant has or has not done something that a lease or rule is required to do, and that probably the most common example is paying rent on time, and there's a late fee, that charge is what is under the law known as a liquidated damage. And so in those instances, that charge, there must be a reasonable relationship between the cost that, in this case, the park takes on because of that late payment of rent, and the late fee itself. And oftentimes there's not that reasonable relationship. So if we're talking about a late rent late fee of even $50 a month, but certainly anything beyond that, it would be really hard for a park to show that those are the costs that it had because of the single late payment of rent by that tenant. So that's another issue to be alert to. So not a lot of limitations, but there are a few. So we commonly hear about issues related to utilities in communities. And as you probably know, in Michigan, the only utilities that are regulated by the state government, and that's in the form of the Public Service Commission, are electric and natural gas service. But there are sometimes issues, if a resident is somehow getting some electric or natural gas service through the park is generally prohibited from adding any upcharge, or a surcharge to that cost, because if it does so, it'd be regarded as what under the law is called a reseller of a utility, which there are limitations and in some cases prohibitions about. A unregulated area, unfortunately, is water service, and know that there are a lot of water service issues in parks. So if the park is getting its water from a municipal provider, that provider may have some rules that limit, again, things like surcharges that a park could add. So, if that's your situation and you think that the water and sewage charges are, out of line with what a customer in a stick-built housing situation is paying, that might be something to follow up with the municipal water service provider about. And as the Michigan Environmental and Great Lakes and Energy Agency, EGLE, has oversight of water and sewage systems. And so on the last slide, there's contact information for different agencies. And just about utility connections, sometimes hear about these issues, and some of you may know more about them than I do, but that the resident is responsible from the point of the connection. So there's the connection to the natural gas line, for example, and for maintaining that, and that can be an issue. So yes, and hear about this quite often, parks not maintaining the so-called common areas within a park. So those are roads, really, that is all the space except for the resident lots. And in cases where the park is renting a home to a resident, the park is responsible for maintenance of the property. And a lot of parks we see try to use things like rent to own or variations on that. And sometimes, those arrangements aren't entirely legal. So the kind of the default standard for mobile homes under the Mobile Home Commission Act is that there must be a transfer of title at the time of sale. And so if there's any payment being made with rent toward the purchase, we'd contend that that's a sale and that the tenant, the resident should get the title, and that then the park would have a security interest, kind of be like a lender on that title. So in instances where a park, whether as a landlord of a home or as a landlord only of a lot, is not keeping the premises, the common areas in repair, there are some remedies under Michigan law that a tenant can take advantage of. One is rent withholding. Another is repair and deduct. It's a little harder to do, I think, repair and deduct when we're talking about common areas. But what you want to be sure to do is, if you are contemplating taking any steps like this, to make sure to do it in writing, to have a written record, which is good both in terms of documentation and as potential evidence of your having made a request or demand for repairs, and also could provide protection in the event the park takes some retaliatory action against you because of your asserting your rights. So park rules, this is and Paul and I think a few others have mentioned, this is a really fraught area. There's a question in my mind, at least, about the legitimate scope of these rules. So we're going to talk about it momentarily, but the just cause termination provisions and what they require for a just cause termination of tenancy case based on a violation of a park rule is that the rule be related to health and safety, the quiet enjoyment of the premises by other residents, or physical condition or appearance of the home or park. And I think probably most park rules fit under those categories, but there's a question, at least in my mind, about park rules that go beyond those categories, of whether those rules are valid and enforceable. So that's a potential issue for further development. And yes, Michigan law, it's not as strong as in many other states, but does recognize some right to tenant organizing. And it does this in this state statute that prohibits evictions in retaliation for tenants exercising some rights, which would include organizing rights. So there is, again, the protection isn't as robust or strong as it is in some other states, but there is definitely some protection under Michigan law for tenant organizing in the manufactured housing setting and beyond. And just, I mean, this may be an issue that many of you are aware of, but just of tenants being liable for payment of personal property tax for so-called leasehold improvements that they make to a home, things like I've listed here: sheds, carports, decks.
Ooh, they can do that.
I think we're going to probably move to the next. And is that the final?
Come on, go. There we go.
Yeah, so I guess now, evictions, and we'll kind of move through this one quickly. So under Michigan law, there are basically two types of eviction cases. One is for non-payment of rent, and the other is this broad category of termination of tenancy. So there's some specific types: illegal drug activity on the premises, health hazard, injury to premises. It has to be a continuing situation, or causing or threatening injury to a non-family member on the premises. And then specific to manufactured housing is this just cause termination. So it's not enough for a mobile home park to not renew, say, we're not going to renew your lease, although there's a little dispute about that, but it's our strong position that a park doesn't have the option of saying, we're not going to renew your lease and you have to move. Our position is that the park has to establish just cause to terminate a tenancy. And as I said, that it applies at all stages of the rental. And this right also includes in cases where a park proposes to terminate a tenancy, a right to meet with the owner and to sell the home on site after the tenant moves on. And I know this is going to be a little hard for you all to see, but here is a listing, and you may be familiar with these, of what are the grounds for just cause. So, again, as with so much other of Michigan landlord tenant law generally, and specifically law applicable to the manufactured housing setting, that these protections aren't as strong as would be ideal, but still, they require that a park, establish one of these grounds in order to be entitled to a judgment in an eviction case for termination of tenancy. I'll just get through this, just a couple of points, and maybe I won't even add to it, just in the interest of time to keep things moving. I think that Paul's going to get you these slides. And so, yeah, I'll just leave it at, I'll leave it at that.
Okay. And then there was the contact information, right?
Yes, one last slide. Yeah, just some, I think what I would call, common, the Mobile Home Commission, Secretary of State for title issues, the Public Service Commission for electric and natural gas issues, the Michigan Attorney General, to whom complaints can be made. And then another resource that is not just on manufactured housing issues, but on a range of legal issues is Michigan Legal Help, which I'd highly recommend to you. And it's connected to my program, so I'm a little self-serving in recommending it. But objectively speaking, it's a really great resource. So recommend it to you if you're not familiar with it.
Okay. And then I'm gonna share this real quick. And then I'm gonna take over from Jim. Can everybody see my screen? Yes. Okay, wonderful. So some common problems, like Jim was talking about with the Consumer Protection Act, and then these surcharges or fraud issues. The common problem that we see is a constant stream of managers or maintenance issues because, you talk to this manager or whatever. And then, when the park starts buying homes and actually renting them to people, and I don't think we have any renters here tonight. Is that right? Yeah, no renters. Everybody's an owner of their home. Okay, so I'll try to keep this. I went into a little bit depth into these fees that we keep talking about, which ones are actually illegal and which ones are allowed. So they're kind of tied with the Consumer Protection Act, and they talk specifically about which ones are deceptive and methods. One, directly or indirectly charging or collecting a fee as a part of entrance, as a condition of just moving in. Requiring somebody to indirectly or directly purchase a mobile home from another person as, again, condition of entrance. So you can't bring your own home, you got to buy one from somebody else. Directly charging a refundable or non-refundable exit fee. So, one of those things is, I think somebody was talking about a $30 annual maybe lease fee. Those fees would probably be somewhere in here, requiring or coercing a person to purchase, rent, lease goods from another person as a condition of any of the following: entering into the park, selling a mobile home, or renting a space in the park, whether it's a seasonal or regular mobile home park. And then we were talking a little bit about utilities. Utilities specifically are whether you are, if they're going to directly or indirectly charging or collecting from a person electric, fuel, or water without the use of that service by the resident or tenant being first, quote, accurately and consistently measured. That just means they have to have a meter on your house. So they can't charge you water and sewer charges unless they're actually measuring them. And little side note on this one, we actually had a park up here go to wireless measuring of the sewer based on gallons that flowed through the pipe. And they went and put these little monitors on everybody's pipe under everybody's house, and then added heat tape. And then they put these things on and measured it. So now they could charge them for sewer. And, they had accurate and consistent measurements with it. So then they could measure how much you were using. A lot of people are doing that for water too. And again, here's the big one: without offering a written lease. So when one of the residents, I want to say it was Deb, was talking specifically about this no lease or month-to-month fee, clearly illegal, that they cannot rent a home, renting or leasing a mobile home or a site on a mobile home park without offering a written lease. So I just went to court on this. I just settled this issue. It was a $250 month-to-month surcharge in Traverse City. And it was absolutely ridiculous. They refused to offer her a written lease, and it was an illegal charge. So we, as legal services, she called us Evictions. We fought it and we won. We ended up mediating the case. And so luckily there was no confidentiality policy in mediation. So we were able to get that taken care of for that client. But and then you have the right, if you are evicted or for non-payment of rent, you have the right to sell your mobile home on site for a price determined by you. The little nuance here is you got to keep paying lot rent while you're selling your house on site. And so if you're evicted for non-payment of lot rent, that puts you in a situation where, yeah, you have 90 days to sell it, but they can actually lock you out of it during that time and require you to continue paying lot rent. And so it's a very, you're definitely going to want to, reach out. So remedies and prevention. You've heard a lot about the law, and obviously, Jim and I are lawyers. This is what we do. So remedies and prevention, what you as tenants can do: read your leases, read your rules, read your leases again. Even when you think you know your lease and you want to talk to the residents about, read it again. And then read your rules and read them again. Knowledge is power, and that is the biggest thing that you're going to have. A lot of people don't even know that they have rules, let alone that they've signed to, abide by them. And so the next step that I put in here is understanding your lease and understanding the rules. And that's why we're here tonight. So everybody can talk to each other about what they are. And then as Jim was saying, reach out to management, do what you can to, get to know them. But when you do need something, do it in writing. Don't just assume that your great relationship with the manager is going to get you what you want. You have to do everything in writing and keep a copy for yourself. Record keeping, prove your case. And then when you do need to reach out for legal services, do it at the first sign of trouble and not the last. I.e., don't wait until you have a court date to call us, because oftentimes we're so busy that, we really can't get involved until the last minute. Obviously, the other remedy here is working with us, working with MH Action here in Paul. But most importantly, what I think some of you are touching on is this formation of tenancy organizations. You're going to get pushback. The managements don't like it when, the bug's life, when the ants rise up. So they like to be able to charge their fees, and especially certain managers, they love to be in control. So when you form these tenancy organizations, you have to hold meetings with minutes, gather obviously, so that people know who's a member of the tenant organization. Doesn't have to be incorporated. It can be one piece of paper that says, I agree to be a member of this organization. Unincorporated, just an organization of people. I did it for one lawsuit and it worked great. It made everybody feel so much more like they were a part of a group and they weren't just being singled out by the management. So hold those meetings, hold them with minutes. There is retaliatory eviction protection against you in Michigan, so don't be afraid of doing that. And with that, that's really the crux of mine is, that you have these rights. You have these rights essentially to have your utilities measured and so on and so forth, and to against these fees, especially if there's a month-to-month fee. And in Deb's Park, where they're hearing about other people that are being faced with these annual fees, question them, form your organizations, read the law, reach out to legal services, get a legal opinion that says whether or not these fees are or are not legal. And, we can write letters to the management and to Sun Communities or whoever the corporate owner is and so on. So with that, I think that's our about 20, 25 minutes. Am I right, Paul?
You are amazing. You all were moving fast. And so I want to just reiterate, I put it in the chat, everyone's going to get a copy of those slides. We're going to have more time. I definitely heard the answers to some of the questions that people were asking and some of the things that were brought up in the introduction. And so, but they also went by quickly. I am going to stop recording now because that was one of the things I meant to do.
Can
All
I
right.
can I say something that